Good morning, dear colleagues. Let's start a special joint meeting in which members of the PCI participate. Robin Heinbrook-Heisen, the chair of the PCI, Norman Aas remotely, Mary Kay Butler remotely, Gabriele Jotkaite Granskiene remotely, John J. O'Sullivan, Jessica Lott Thompson. We have also in participation members of the HQCJ Mihailo Bohanis, Lyudmila Volkova, Vitaliy Gatsalyuk, Yaroslav Duch, Roman Perdysyuk, Nadia Олексій Омельян, Роман Сабадаш, Руслан Сидорович, Галина Шевчук. I am the presiding member of TGZ, Oleg Kolyush. We have also the secretary present here, Katerina Doroshenko. We have the quorum, and the special joint meeting of the HQCJ and the PCI is announced to be open. Just to inform you that we are having the broadcasting of this special joint meeting. And we have the following agenda announced for today. First of all, regarding compliance of candidates for positions of judges of the High Anti-Corruption Court with the Part 4, Article 8 of the Law of Ukraine on High Anti-Corruption Court. The list of candidates for today: Vitaliy Viktorovych Kryklyvyi, Oleg Petrovich Kostюk II, Denis Sergeyevich Kovalenko III. And the second question regarding correction of the error regarding consideration in the special joint meeting of the High Commission of the HQCJ and PCI, Katerina Koteleva, with her compliance with Part 8, Part 4, Article 8. And the third, correcting mistake in the decision of the HQCJ as of 18th February regarding consideration in the special joint meeting on compliance of Kim Sachov Sergei Oleg Sergeyevich with criteria envisaged in Part 4, Article 8. The question number 4, the issue number 4 in the agenda, to correct mistakes in the decision of KCZ as of 25th February regarding consideration of compliance of the candidate with Kryklyvyi Viktorovych with criteria envisaged in Part 4, Article 8 of the Law of Ukraine on the High Anti-Corruption Court. Are there any other proposals from the Commission members to add into our agenda for today? No, then let's vote for. Who is for? The PCI members, are you for? And the decision has been made unanimously. Let's go to consideration of the first issue in the agenda. Dear Secretary, please inform us where we have candidates here. The invited candidates for positions of judges of the HACC, Kryklyvyi Vitaliy Viktorovych, Kostюk Oleg Petrovich, and Kovalenko Denis Sergeyevich, has been present in these premises. Please invite Vitaliy Viktorovich Kryklyvyi as a candidate for position of the judge of HACC for his interview. Hello, please be seated. We are considering the issue of compliance of candidate Vitaliy Viktorovich Kryklyvyi for the position of a judge of HCC with criteria envisaged in Part 4, Article 8 of the Law on HCC. We have here present members of the PCI, Robert Brookheisen, the chair of the PCI, Norman Aas remotely, Mary Butler remotely, Gabriele Jotkaite Granskiene remotely, John J. O'Sullivan, and Jessica Lott Thompson. We have here HQCJ members, Mihailo Bohanis, Lyudmila Volkova, Vitaliy Gatsalyuk, Yaroslav Duch, Nadia Kobetska, Oleg Kolyush, Igor Kushnir, Ruslan Melnik, Alexey Omelian, Roman Sabadash, Ruslan Sidorovich, Sergei Chumak, and Galina Shevchuk. Is it clear for you, the composition of this commission? Yes. So, your rights are the following. You have a right to submit motion on recusal of Commission members. Upon agreement of the presiding Commission member, you can express your opinions regarding questions considered during this interview and challenge the decisions of the Commission according to legislation. Just to raise your attention, during this meeting, we do not consider any documents if they were not submitted before, but the candidate has an opportunity to submit them. And if we have an initiative of at least 3 members of the PCA or a commission with the majority of votes of the PCA and QCJ, there could be decision made on attaching the documents presented during the interview if we have votes of at least 3 PCA members. Vitaliy Viktorovych, is it clear for you? Your rights? Yes. Do you have motions on recusals or any other motions? No, I don't have. Okay, it's clear. The rapporteur on this candidate, we have Lyudmila Mykolaievna Volkova. Madam Volkova, over to you. Thank you. By decision of the Commission as of June 3, 2025, a competition was announced to fill 23 vacant positions of judges of the High Anti-Corruption Court and the Appeals Chamber of the HACC. Within the established time limit, Vitaliy Viktorovych Kryklyvyi submitted an application to the Commission requesting admission to participate in the announced competition, and with the decision of the Commission, he was admitted to participate in the qualification assessment and participation in the competition. By decision of the Commission, general results on qualification examination were approved, and the candidate scored 342.62 points and was admitted to the second stage of the qualification assessment. Review of the dossier and interview. In 1997, a candidate graduated from the University of Internal Affairs and received a full higher education degree in jurisprudence, obtaining the qualification of a lawyer. The candidate holds no academic title or degree. In 1997, Mr. Kryklyvyi graduated from the university and from February 2000 to September 2003, he served as a senior investigator in the investigative unit of the tax police of the Komsomolsk City State Tax Inspectorate, and subsequently as a senior investigator in the tax police department of the Kremenchuk Joint Tax Administration in Poltava Oblast. And from September 2003 to April 2019, he was appointed also as a judge of the Komsomolsk City Court of Poltava region. From April 2019 to the present time, he has held the position of judge of the High Anti-Corruption Court. The candidate has submitted declaration of family ties, integrity declaration of a candidate for the position of a judge. During the competition, the Commission sent inquiries to the State Judicial Administration of Ukraine, the Security Service of Ukraine, the Office of the Prosecutor General, the State Border Guard Service of Ukraine, the National Agency of Corruption Prevention, the National Police, the NABU, the Ministry of Justice of Ukraine, and other public authorities, and we have received relevant responses. On February 16, 2026, the Commission received a letter from the NGO Anti-Corruption Action Center regarding candidate Kryklyvyi for the position of judge of the High Anti-Corruption Court of Ukraine. We are going to discuss issues presented there in that document during this interview. Thank you, Halina Mykolaievna. And if everything is correct, now there are no reservations, then I give a floor to Mr. Robert Broekhuizen. Please, over to you, Mr. Robert.
Thank you very much, Mr. Chair. The rapporteur in this case is Jessica, so the floor is yours. Good morning, Mr. Kryklyvyi.
Good morning, and thank you, Mr. Robert. Good morning, Mr. Vitaliy Viktorovych. My name is Jessica Lott-Thompson. I'm a lawyer from Canada, and I'll be the rapporteur in your matter. I'd like to introduce you to the other members of the PCIE who are here in the room as well as online. So if you look to the screen, you will see on the far left, Mary Butler, who is a prosecutor in the Department of Justice in the United States. In the center, Norman Aas, who is a former prosecutor and lawyer in Estonia. Gabriel Jodkate, who is a Chief Justice of the Criminal Supreme Court in Lithuania. And here in the room with me to my far left, John O'Sullivan, who is a retired judge and former prosecutor from the United States, and our chairperson, Robert Broekhuizen, who is a former prosecutor and lawyer from the Netherlands. So to begin, I'd like to congratulate you on arriving at this stage of the process and for your thank you for your participation in the written stage with the exchange of questions with PCIe members. For candidates, for this process to be effective, it's essential for candidates to participate transparently and openly and to provide supporting documents for our questions. And thank you for the efforts that you have made to do that. I'd also like to highlight that from those written questions, many of the issues that I will ask you questions about today are the same issues that have already been addressed in your written questions. And so please feel free to repeat any of the materials that you have already, like it's okay if you find that you are repeating. It's not that we have forgotten your answers. It's that the purpose of this oral interview is for the public and for transparency and for the CSOs and various agencies who have submitted questions for us to be able to provide this transparency for them. The other final thing I'll remind you is time management. So time management is an essential skill of a judge. Today, we will have limited time to discuss many important issues, and it's in your best interest for us to be able to address all of those issues. I would encourage you to contain your responses to be as brief as possible. Remember, we have seen your written answers, and so I'd encourage you to keep your answers to a brief period. Unless you have any questions for me, I'll begin. Thank you. Okay, I'm going to first start to talk about some issues related to the time after you were appointed as a judge of the High Anti-Corruption Court. The first topic I'd like to discuss is your assignment of a 4-room apartment, a service apartment in 2019 as a judge of the High Anti-Corruption Court. During that time, you were living as one family with Mrs. Kryklyvyi, who at that time was Havrirenko, and she was the chair of the Housing Commission for the High Anti-Corruption Court at that time. You have provided this answer to us already. Can you please explain this process of how you were granted this apartment in 2019? Please reference specific exact documents and address the role and conflict of interest that could potentially arise with your partner's position with the Housing Committee.
Thank you. After my appointment as a judge of the High Anti-Corruption Court, and according to specialized law on this court, judges who were not provided or who didn't have their own accommodation in the city of Kyiv, they were eligible to receive such housing, and this housing was provided only during the period of fulfillment of the duties of a judge of HSCC, and there was no grounds for giving such housing into ownership of any of the judges. So there was a direct ban to give it into ownership. As a judge of the HSCC and as a person who didn't have any own housing, the same as Madam Havrilenko, we submitted our motions or applications, and we were included into the list of judges who required granting of such accommodation. And the relevant procedures were taken in order to assess the value of that housing. So we lived as one family at that moment, and Madam Tatiana refused. She submitted her application. I don't remember the specific dates when it was. It was November 2019. What specific date, I don't remember. So she submitted her refusal application that she refuses from this housing, not housing, but from this right to receive this housing as a judge. And so we had a family of 4 persons, and there were 2 minors and 2 adults. Later, in January next year, 2020, our situation, our relationship has deteriorated between me and Madam Gavrilenko, and I informed her about my decision and that I'm not going to live as one family as with Madam Gavrilenko, and I submitted a relevant application because I realized that, it's quite hard to receive housing for 4 people, and in order to avoid any risks regarding my transparency, I clarified the situation and I submitted my application for housing of 2 persons. So, and further, as my application was already submitted, and based on Madam Gavrilenko's application, this apartment for 4 people was given for her accommodation, and afterwards, when our relationship has improved, and we renewed our family relations, and since that moment we started living in that apartment. We have not submitted any other application for any other apartment or housing. It's the same apartment. There were no benefits received, no discounts received based out of this procedure, and we didn't have any goal. Yeah, I understand that it looks quite strange, but it happened how it happened in our life, and for now it's not very convenient for me to mention it out loud, but during that period, there was that period when we arrived to Kiev, when our lifestyle has changed. We have narrowed our circle of acquaintances and communication. So we're in that situation, and at that moment, it led to the station when our family relations have deteriorated, and as a result, that's what I mentioned.
So, aside from the family relations, you don't need to go into detail about that. The thing I'm more interested in is issues related to the potential for conflict of interest and procedural steps to obtaining the apartment. The specifics from when you withdrew in January 2020 and then later on returned to the apartment. Can you address whether this appears to be some coordinated rearrangement of the same housing benefit within the family?
So, potential conflict of interest of persons working in the same court, indeed, it could exist, but under that specific situation, it was regulated in the following manner. Madam Tatiana Gavrilenko, as the chair of the commission, she didn't participate in voting for that decision, and the voting was carried out by a panel of members of the Housing Commission. That's according to the procedure, and this procedure is aligned with the Chamber of Judges of Ukraine, who actually recommends this specific procedure in order to regulate this potential conflict of interest. There were no arrangements from my side and no arrangements between me and Madam Tatiana Gavrilenko. I think that was a situation. At that moment, we have lost an opportunity even to have normal communication between ourselves.
I'll move on to another issue. There is a complaint that was assigned to you while you were serving as a judge of the High Anti-Corruption Court on the 25th of June in 2005 that had to be considered within 72 hours, which is a procedural requirement for many matters that come before you as a HAC judge. However, you did not consider this matter until the 29th of July, 2025, so approximately 1 month and 4 days after the complaint was initially assigned to you. Can you please explain this quite strong breach of the statutory deadline of 72 hours? And why did this occur? Do you have some explanation for this long gap?
I remember this case, and I provided written explanations regarding this matter. So under that court hearing did not take place. That was a Friday. I was very busy with cases, searches, preventive measures, and I listed the cases that I was considering at that time. And unfortunately, that case did not take place later on. So it was postponed with the participation of another party, another representative of the defendant. And that case was about appealing a notice of suspicion, and it was necessary to consider the materials justifying that appeal. So the case was postponed, but the materials failed to arrive from the investigator. Investigator sent another request of postponement, and then the defendant did not appear in court again. And this category of cases can only be heard with the presence of the plaintiff, and with the absence of the materials, I withdrew that case and informed the defendant that the following week I would be on an annual leave, and I warned them that the hearing would be postponed indefinitely. Then motions could be done, but the court didn't have lawful circumstances to hear the case again. So it was done on the first day after my annual leave. And the decision was taken on the basis of the materials from the pretrial body. So indeed, violations of the limitations happened, but in terms of lawful interests of the plaintiff, no violations happened. The right to appeal, the right to get a court ruling were realized. And the court of a higher instance checked this decision.
I'd like to clarify my question a little bit more. So thank you for explaining some of the steps that you took. But even in accepting your explanation about the filing of the matter on Friday, the absence of parties, missing materials, and vacation leave, can you please explain what concrete steps you took to personally ensure that this complaint was still considered within the statutory timeframe and according to the rules of procedure? I understand that it is possible in extraordinary circumstances for there to be sittings of the court on weekends and on Fridays, although it is not the standard practice of the High Anti-Corruption Court, that there is some on-call judges and potential for weekend hearings. Can you please explain the steps that you personally took to ensure that this matter could be dealt with promptly? Sorry, actually,
First,
if there's anything in addition, you don't need to repeat your previous answer.
I will repeat just one thing. So that court hearing was supposed to happen on time, but then, because of the circumstances that I mentioned, it was postponed. And as I said, under the law, we are supposed to hear such cases only in the presence of the defendant or their representative. And given the workload of the investigating judge and the workload of the defendant, we are finding a balance. But the defendant failed to appear, and the attorney wrote an application about a notification about the defendant's absence. So the rights and obligations of the plaintiff and the defendant is to be present before court.
The complaint indicates that after the 17th of July of 2025, the case could have potentially fallen outside of the jurisdiction of the High Anti-Corruption Court. How did you address this question of jurisdiction in this case, and was it what was the basis for proceeding on the 29th of July in 2025 in that in addressing that issue?
It is my belief that coincides with the appellate courts, other appellate courts, and other investigating judges involved in this proceedings. That case did not fall out the jurisdiction of the Hague because, but that time, that case was finished, and the complaint was about a sum of compensation. But when I considered the case, court expertise were still ongoing, and saying that that case would fall out from the Hague jurisdiction would be impossible because the plaintiff and the defendant until November 2025 actively approached the appellate court with their claims and appeals, and they demanded that the case be heard in that court. So it was not obvious that the case could fall out the jurisdiction of the Hague.
Okay.
So
I'll move on to the next topic. The next topic relates to some loans that were taken by yourself and your current wife in 2019 from a relative of yours. Both you and your wife each borrowed $25,000 from your relative in 2019, and again in 2025, you again borrowed just over 1 million hryvnia from the same relative. Can you please explain why this relative repeatedly is acting as a major private lender to you and your family? And give some specificity as to the nature of the relationship, other than just, what type of family member? Is this a financial partner, a business partner, an occasional lender? Someone who is long-term involved in your financial dealings, or some other type of relationship. So please give us some more detail other than just, the type of family member.
yes, indeed, this relative provided us loans on multiple occasions. This is my cousin. It's a son of my father's brother. And after my parents died, we were close, but after my parents died, this is my only family member along my father's line. And our families celebrate holidays together, my birthday in particular, at his place, my relative's place. Then Christmas, we always come together. And regarding the financial possibilities, he can afford giving such loans because he has an enterprise for a long time. He has had it for a long time already, and he pays taxes officially in Ukraine. And I provided you the proofs regarding this. I'm not naming the numbers, but the sums are considerable. And he didn't have any trouble giving us those loans. Those were 3 loans. Should I continue?
I'll ask some additional questions. Can you clarify whether this is a business partner? Do you have any other financial dealings with this same relative, or enterprises that you engage in together, shared bank accounts, or any other financial relationship other than these loans with this person?
No other relationship other than a family relationship, no joint business, no shared bank accounts with him. We live in different oblasts, and recently he has lived abroad the most part of his life.
Now I'd like to ask you some questions about issues that relate to the time period before you became a judge of the High Anti-Corruption Court. So specifically, I'll begin with your repeated chairmanship of the Komsomolsky City Court between 2006 and 2019. You have responded already on many occasions in screening competitions in relation to this issue. But I would like you to please address this now for the transparency of this process. Why did this administrative role remain in your hands for 13 years? And in your view, why would no other judge have attempted to take this position during that period?
I will start with your last question. So, Komsomolsk City Court, I have indeed been court chief for more than 13 years. One of the reasons was that no one else wanted to take this position because it was a responsible position. And there was no volunteers. There were no volunteers. Then, the first time I was appointed to this position by the presidential decree. Canal, English channel, testing. Testing, 111.
Everyone else, but my headphones just made a loud noise and then stopped working. Maybe only this machine is broken.
What should I repeat?
Go ahead.
What, should I continue or should I repeat?
I missed maybe one sentence. When you said the court chief position, nobody else wanted to take this position. I just missed a few words.
And so I was appointed to this position as the only volunteer. The first time I was appointed to this position by the presidential decree, later on by the decision of the Judges' Council of Ukraine, then the legislation was amended, and I was appointed by the Judges' Assembly through secret vote. But each time when I was appointed, legislation would change. The reform of the judicial system took place, and taking into account the explanation of the Judges' Council of Ukraine, even though I took that position before, based on the regulatory framework adopted at later periods, I was able and I was eligible to this position once again, over and over again.
For sure. Can you comment? I'd like to know your thoughts about this situation, which can occur particularly in small courts, where even a formally lawful repeated reappointment of a head judge may create a perception of excessive concentration of administrative influence. Can you comment on the reforms to the judiciary in Ukraine and the importance of this issue, in your view, to the modernization and reforms of the judiciary in Ukraine? Specifically, if you can consider, I'm interested in your thoughts whether there are any concrete safeguards beyond simply this general reference to the Judges' Assembly that can prevent this perception or a real dependence, this type of informal influence on the court. Do you have any thoughts on concrete safeguards in relation to these types of reforms?
Враховуючи, що я обіймав посаду голови суду з 2009 року, я можу...
Because I have been in this position, was in this position from 2009, I believe that the reform of the judiciary system was a successful one, because the court chief had a lot of issues at his discretion that go beyond, should go beyond their discretion. And the steps that were made to limit that were successful. And regarding the safeguards, I took the following steps. I never took the cases from other judges intentionally. Then, regarding the influence on the working process, I did not encourage my colleagues to encourage them to take any certain steps or decisions. And I just made sure that the court staff workflow was organized well. The court hearings happened on time. So I think it was more of a managerial position, and as long as you manage the court's workings well, and as long as you don't interfere in those workings, even more so than other judges don't wish it, then it can work out.
It really is the type of position that concentrates so much responsibility and ethical importance for the person holding the position, for sure. The individual matters a great deal. I'm going to move on to a new topic, the rented apartment in Khartoum. Between 2017 and 2019, you declared an actual residence in your declaration as an apartment owned by an individual, an apartment owned by an individual named Mrs. Khartoum, which, and this individual in 2010 had previously been involved in a case where you were presiding as a judge. Can you please explain your rental arrangements in relation to this apartment and any relationship or knowledge that you had of Mrs. Khartoum, who was the owner of this apartment, prior to renting it or during the period of renting it?
So I can understand your concern, the concern of the PCIe members, HQCJ members, concerns on the part of society and CSOs regarding this, but I can indicate the following. So first, between the consideration of the case in 2010 and the leasing agreement, more than 7 years passed. And when I considered the case and when I concluded the leasing agreement, no relationship evolved between myself and Khartoum. Komsomolsk is a small town, that's true, and I considered many cases within Komsomolsk City Court. It is one of the most workloaded courts in Ukraine. And because of this long period of time that I serve as a judge, and I have considered many cases of the citizens that reside in Komsomolsk, but I have never maintained any kind of relationship with this lady, and I found that apartment with the help of a realtor, of an agent, leasing agent, and I believe that there was no conflict of interest or any other concern regarding integrity in this situation.
And were there
And regarding, and if you're interested in the closure of the case, I turned to the court as I prepared for the competition, and I was given the information that the case reached the court on April 6, 2010, and it was closed again because of overdue time limitations. And I only had 19 working days to consider this case until the limitations would be over. And the offense itself took place 3 months prior. And physically, it was impossible to consider this case properly on time, because once again, you need to have the presence of the defendant. Then if they don't appear, you need to make a notice of suspicion in absentia. You need to consider the evidence, and there was none of it, and that is why the case was closed. But it is by no means related to the leasing of the apartment, and more than 7 years passed since then.
My only other question is, were the rental terms for the apartment, the amount of rent paid and the general terms of rental through this third-party rental agency, were they consistent with market conditions and market rates at that time?
Well, in such a town as Komsomolsk, yes, it was 4,000 hryvnia. It was compliant with the market value for a lease of an apartment of that size, and also 4,000 plus utilities.
I'm going to move on to another topic. Some travel that occurred for you in March of 2016 and September 2015 to the Russian Federation. By 2015, Russia had invaded and annexed Crimea. There was war actively occurring in the Donbas region, and the Verkhovna Rada had already declared Russia as an aggressor state. These are historical events that were occurring at this time. As a judge, before you took these trips, how did you assess the reputational risk of traveling to the Russian Federation at that time? And please describe the trips and why you took them.
Yes, indeed. In 2015-2016, I visited the Russian Federation. At that time, there was no legal prohibition to visit the Russian Federation. There were only warnings regarding the temporary occupied territory, some limitations, and I didn't do a good job enough of evaluating reputational risks and assessing that decision. But now that the Russian Federation invaded Ukraine, I totally refused. I'm opposed to the idea of going there. So first, it was the first trip was to Kamchatka for tourism. We were going by boats in that region. And the second trip, my mother asked me to accompany a common friend, family friend, to Belgorod in order to collect their pension. And that person lived in the temporary occupied in the territory of the Russian Federation, and that person was 83 years old. Their health was deplorable, and my mother asked me to accompany that person to the bank where they got their pension and registered their pension in the international bank account later on to get it in the territory of Ukraine.
Another area of questioning. Our time is getting quite short, so I'd ask you to keep your answers as brief as possible. This area of questioning relates to some alimony payments upon the dissolution of a marriage, a dispute related to alimony prior to your becoming a judge of the High Anti-Corruption Court. It appears that in a court decision dated the 8th of June, 2020, your former spouse had alleged that you had a period of 6 months where you were not in contact with her and had not been providing financial or medical support to one of your daughters who has a disability. Can you, in that same case, you also proposed alimony of 1/14 of your income to go towards that child as child support. Can you please explain this allegation that you were not in contact or sufficiently providing support to your child, and explain why the rate of 1/14 of your income was seen by you as appropriate for in that case?
I remember that litigation, and the matter was the following. For some time, my wife, my ex-wife, abandoned me with a child with a disability and left. And she said that she had gone to vacation. So she went abroad to Czechia, where she has a child from her first marriage. And she wanted to stay there. And I paid alimony through the accountant's office of the court. When she was back, she asked me to pay her alimony to her bank account officially. I agreed because that procedure became simplified. So, but nevertheless, she filed a claim to court. I was running in the competition for the head court judge position. In her claim, she stated that I was evading payment of alimony, but in the court ruling, if you read it, you will find that I paid alimony to her bank account and I provided all the documental proofs. And regarding the amount of the alimony, the law of Ukraine does not set any certain maximum or minimum amounts. Well, it might, but with regard to certain criteria, the conditions, the health conditions, the living conditions, and based on the salary of the party. And I always was involved in upbringing of my children, and we managed to find common ground and close the case. And until today, I'm fulfilling my parental duty voluntarily, and the period of alimony was extended, and I do pay my alimony.
Voluntary payments that you have made over the years towards your daughter's medical care and general upkeep? If you have any further comment, from for how many years have you been sometimes making additional voluntary payments?
Ну, спочатку, з того дня, коли
Well,
наші стосунки погіршилися, я став
From the day when our relationship got worse and we started living separately, and currently in the accounting office of the Hague court, there is my application with the request to have a part of my income transferred to as alimony, and that is done regularly and timely.
So you have a garnishment arrangement set up with your employer in order to provide support to this alimony support. It sounds. Yeah, okay. I'm going to move on. This is my final question. Actually, no, I have no further questions. I see that we are at time, and thank you for your answers. I'll check and see if any of my colleagues have questions here today in the room. Robert? John?
No, thank you.
And online, does anybody have any further questions for this candidate? Shaking their heads no. Thank you very much for your answers today and for your participation in the written portion of this, and I'll turn this back to the chair.
And back to you, Chair.
Дякую. Так, я для протоколу відмічу, що
Thank you. I will also note down for the minutes of today's meeting that I'm passing already take the role of presiding commission member. So, thank you. I have the first question to you related to administration of justice. My question is the following. Tell me, during your work at the High Anti-Corruption Court of Ukraine, have you performed the role of an investigative judge during a whole period of time? No. I was assigned for sorting periods. Okay, when specifically you performed the role of investigative judge? It was 2021, 2025, to give or take, more or less. I think starting December 2020 to 2021, something like this, and also December 2024 to October or November 2025. Okay, tell me, please. If we take your workload, what were the reasons that during that period of time you had a much lower workload in comparison with other judges of the High Anti-Corruption Court? Specifically, given the fact that at that time you also performed the role of an investigative judge, it means that it should have increased your workload rather than vice versa. I don't know how you calculated it. So what do you mean under comparing with workload of other judges? I mean comparing with all other judges, your workload was lower. Now, to your opinion, what was the reason for that? It's hard for me to answer this question, as we have the automized case distribution system. So I reviewed all the cases which I was assigned to. That's why for me it's hard to reason why was it. And specifically in our courts, we have also the specific table on complexity coefficient of cases. So it means that cases could be different difficulty. They could be challenging or simpler. So you had more challenging cases rather than simpler cases. No, I can't tell it. So it's the system which actually defined this coefficient of complexity. No, I mean under your consideration. So you know your cases. Yeah, I had not simple cases, quite challenging ones. But I don't know what were cases of other colleagues, judges. I worked only on my cases. Okay, thank you. During your period of work in the High Anti-Corruption Court, how often you and your wife submitted self-recusal motions because of your roles as investigative judges. Yeah, I expected this question, and I wanted to say that it's not that there were not so many. So starting September 2019 until now, Tatiana has submitted self-recusals because of her role as an investigative judge, maybe 10 times, more or less. And for me, I submitted self-recusals 3 times. Yeah, but I also would like to mention that during certain periods of time, I carried out certain reviews for our team of judges, and starting 1st January 2022 to 1st October 2023, in our court, in total, there were 163 applications on self-recusals submitted, on recusals submitted by judges, and half of them, these were self-recusals submitted because of combining role of judge with the role of investigative judge. So, generally speaking, our statistics is even lower than the average number of self-recusals per judge. And regarding our work in panels, we didn't have any self-recusals at all. Okay, thank you. Tell me, if you were appointed as a judge of the appellate chamber, what do you think? What will happen with your workload in this court, considering that either you or your wife have considered certain cases in the first instance of the court, performing the role of a judge or investigative judge? What do you think? Do you think that during the first years of your appointment to the appellate chamber, would you have enough workload, considering your work and your wife's work in the first instance court? You know, I'm sure that we will have the same workload as other judges of the appellate chamber. I would like to pay your attention that judges of the first instance, we have 12 investigative judges, and this figure doesn't impact at all on the workload of other judges while they consider cases, because the case distribution system, that's automized system, and this system takes into consideration the role of investigative judges when they consider cases, and this issue of judicial control is taken into account. So everything is compensated, taken into account, and de facto the workload depends on the case complexity coefficient and the number of working days. I'm sorry, my question was another one. It was related to your potential appointment as a judge of the appellate chamber. So it means that you will not be able to consider cases which you or your wife considered by merits in the first instance court. No, you're wrong. So first of all, Tatiana was not an investigative judge, so she will be able to consider any cases. And secondly, I was one out of 12 investigative judges, and there were so many different cases and proceedings. They do not overlap. So, you know, now, as a judge considering case by merits, I receive the same number of cases, and it will happen further if I'm appointed to the appellate chamber. It will not impact on my workload. Thank you. Then let's continue this topic of self-recusals. My next question is the following. If you remember, and I'm going back to this topic of assigning you with the service accommodation. Based on the court decisions register, it looks that on 16th March 2020, so the ruling which was made with your involvement in the panel, the motion on self-recusal was approved. And in that ruling, it mentions that at that moment, you, as of 2016, as of 16th March 2020, you and Judge Havrilenko, you were living together, but you didn't have official status, and it could lead to certain doubts. So, and that means that according to the decision of the High Anti-Corruption Court of the Congress of Judges, 3 days later, you declared that your situation has deteriorated significantly. So, did your relation significantly deteriorate during those 3 days, from 16th of March to 19th of March? Or can we consider that the situation which was actually there, it was an artificial situation? No, of course. Not 3 days were required for us to deteriorate situations, but you should differentiate the actual relationship between a couple and grounds for self-recusal of a judge. You know, for an external observer, and according to legislation, we were a couple of spouses, and there were, and so there was a ground for me either to have my self-recusal or recusal of Madam Gavrilenko. No, my question was different. So the ruling which you signed, and at that moment, at that specific moment, that as of 16th of March, you were living together and you had mutual rights and obligations. But as of 19th of March, 3 days later, something had happened. So had it happened during that period of time for 3 days, so so in that ruling you mentioned absolutely different information. Not that you had, but no, that at that moment you were having relations. Yeah, but let's take Article 75 of the Criminal Procedure of Ukraine. According to this article, we had been living together, had mutual rights and obligations. It was an obligatory requirement for self-recusal of a judge, and it's explained specifically regarding our matter. But for the purposes of assigning you with housing, you didn't live together. De facto, no, we didn't live together. Okay, thank you. The next question is related to information mentioned. Sorry, I also would like to just mention, to comment upon that. We didn't have any sense to give untrustworthy information. Okay, my next question is the following. During the period from 2017 to 2020, you failed to mention information about your minor daughter from the first marriage in your declaration. This information is provided by the NGO Anti-Corruption Task Force Center. Yeah, I provided already replies to this because according to law on corruption prevention and the NACP explanations, minor children who were not living together with declarant should have not been declared in declarations. Minor children, so children which were not living with a declarant as one family, including minor children. That's what that law at that moment specified and the NACP explanations. So there was no need to mention here in my declaration. The first time ever when this obligation was envisaged according to law on corruption prevention, it was back in 2019. Then at that moment I made a mistake. Indeed, I failed to declare here. But so as a minor child of me as a declarant. But next year, 2020, I have already declared here in my declaration. So I can only explain regarding 2019. So indeed, in 2019, while filling in my declaration, I didn't take all the amendments to legislation and failed to declare my minor daughter Ava in my declaration. But I indicated where she lived. So anyway, I mentioned here in my declaration for 2016, when at that moment we had lived together as one family. At that moment I declared her in 2016. So I had no reasons to conceal this information, and as I provided in my explanations, so my minor daughter, my Ava, she doesn't have legal capacity, and she has she's not eligible to make any legal decisions, and that was a technical mistake. Unfortunately, I didn't take into consideration amendments to legislation. Upon review of the NACP, I corrected this mistake, and further, I didn't make this mistake anymore. Thank you. Next question is related to the following. That family ties declaration for 2017-2018, there you failed to mention Madam Gavrilenko, but at the same time, in 2018, you had already your shared child born. So it means that we have a question to you that highly likely that as of 2017 and 2018, in your family ties declaration and yearly declaration for 2017, you should have indicated your mutual rights and obligations. Is it right? No. Shouldn't have indicated. We indicated joint rights and obligations 2018, as it happened in the reality. Before 2018, we didn't have mutual rights and obligations because we didn't have joint household, we didn't have joint budget, we had our separate accommodations, lived separately. We even worked in different districts of our Poltava region, and there was 80 kilometers distance between our settlements. So Tatiana Gavrilenko worked in the Novosnezhavsky district court in the Poltava region, and I worked at that moment in the Komsomolsk district court of the same region. So that very fact that we were expecting for our shared child, according to current legislation, doesn't give us grounds to declare such relations. And that's why both of legal conditions and based on common sense, there was no need to declare those relations. So starting March 2018, Tatiana Gavrilenko, we started living together with her. Before giving birth to a child, she was already the maternity leave, she already stopped working in the court, and that's the moment when we started living together and declared our relations. We didn't have any reasons to distort this information or conceal it. Thank you, clear. Next question. The CSO also raises another question regarding your declaration of a room in Kryklyvyi Vitaliy settlement at that moment when you had already lived in Kiev. So, and that room was your actual place of residence. So what information is accurate in your declarations? All information is accurate in my declarations. So first of all, according to NACP explanations, a declarant shall declare place of registration as of the last day of the reporting period. So as of 31st December 2021? Yes, 2021. So in 2021, you said that your actual place of residence was the same as the place of registration. And you keep declaring a room in Kryklyvyi Vitaliy settlement as a place of registration. So it means that as of 31st December 2021, your place of registration residence was Kryklyvyi Vitaliy? No. I don't have my declaration in front of myself, but I trust you, what you are telling me. Maybe it was a mistake. You know, we sent this document of the CSO to you. You looked through it. Yeah. I provided my reply that since 2021 till now, I was registered in Kiev and I indicated it as my place of registration and residence. But regarding Kryklyvyi Vitaliy place of registration, I indicated that before that, almost during the whole year, I was registered at that address. And considering that the distance, the period of my registration was more than 183 days, I needed to declare it. That's why I declared that right for usage, but it was exclusively my place of registration. I didn't use it for any single day. But you mentioned, you put the mark that your place of residence registration were the same. It was a mistake. Okay, thank you. The next question was related to changes in your property ownership status when you mentioned your ownership right for a land plot required in the Kryklyvyi Vitaliy settlement worth of 284,000 hryvnia, but at the same time in the section gifts and income for 2018 you declare the same amount as the sum received from privatization of the land plot. So maybe again there were certain mistakes with declaring process or what. No, I think that I did it in the correct way because I mentioned this amount in section 11, gifts and income. That land plot was received free of charge by me based on privatization grounds and given similar NACP explanations, I declared it as a gift received free of charge. At that moment, there were no other NACP explanations. That's why I thought that it's necessary to declare this information openly, this amount openly. Thank you. And another question related to your declarations. What happens What's happening with your systematic violations committed by you regarding notifications of significant changes in the property status? So sometimes you violated a 10-day period for providing such notifications. Yes, it was done twice. I didn't violate a 10-day period for providing such notifications, but when I submitted relevant notifications, I made mistakes. I made mistakes giving the wrong months of receipt of those salaries. Unfortunately, functions of this system do not allow me to send additional notifications to correct those mistakes. So that's how it was. But I provided my explanations to the NACP. But the mistake was made not only regarding the months, but also the year. You received salary at 31st December 2019, but you informed on 6 February 2020, more than months. Yeah, but I provided some evidences that I submitted this notification within the deadline, and I was compliant with the provisions of the law. Yes, the mistake was made, indeed, but I have my lessons learned, and now I'm paying more attention to information provided to me to the registers. Thank you.
Next question relates to the income you got from inheritance. With your cohabitant in 2019, you say that you got more than 300,000 hryvnia, and your cohabitant states that she inherited 3 land plots. Why is this discrepancy? So she got 3 land plots worth more than 300,000. You stated the amount in hryvnia, and she states land plots. These are different dimensions. I was guided by the NACP explanations that the amount should be. You're stating the cash, and she's stating land plots. Why so? So I'm stating that this is the worth of those land plots. So next question relates to the fact that in the gift section, the declaration 2019 to 2023, you declare the income that your cohabitant got from leasing the land plots. In the state register, there are no contracts regarding real estate owned by your cohabitant. I got that information from Tetiana Gavrilenko Kryklyva and declared that she underwent a check, and that information is reliable. And her income was received from leasing the land plots. And there is nothing unlawful here. Okay, clear. Next question. In 2020, in the section deals, you declare a deal from 2020 regarding the lease of an apartment, but at the same time, there is no information regarding leasing of an apartment in other sections of your declaration in the section real estate. So I provided documents, and I don't really remember now, but I leased that apartment when we lived separately with Tetiana Gavrilenko. I lived in Kyiv, and I didn't state that apartment in the real estate section because as of the late reporting period, I didn't live there, and I could refrain from declaring it. But based on another guideline, I declared it. But there is no clear guideline from an ACP whether we are supposed to declare such situations, such real estate in such situation or not. And the guidelines from ACP are changing constantly, and I decided to stay on the safe side and declare the apartment. And in case an ACP had questions, and they did, I provided answers. And the amount of the lease, did it exceed the amount that needed to be declared? Was it a big apartment? No, it was a one-bedroom apartment, and the amount did not exceed. And there was no clear guideline whether the amount of lease or amount, the worth of the property needed to be declared. And criminal cases sometimes were opened, and because there was no guideline. So this is why I decided to stay on the safe side and declare it anyhow. Okay. Declaration for 2021, you declare cash on your bank accounts, more than 43,000. Your cohabitant, meanwhile, on that same period, she declares your money in your bank accounts worth more than 80,000 hryvnia. Why is that discrepancy? Did you fail to inform her appropriately, or did you fail to declare? In my declaration, the amount is stated correctly, and I provided a certificate, my bank, an extract from my bank record to Tatiana, but she may have made a mistake and added to my assets remaining on the last day of the reporting period 37,000 that I had on a deposit account that I withdrew that month, but information was there in my extract from my bank records, and she did not take that into account. This is an automatic mistake that did not result in any bad consequences. Okay, thank you. Then regarding your house purchased in 2025, your wife informed of that in the changes of the property status. What was the technical state of the house at the time of its acquisition by your wife? Did it need a renovation or repairs? In 2025, it was a residential house ready for living, absolutely ready, yes. On which terms and conditions a credit agreement was concluded? Loan agreement was concluded. Which interest, which period of repayment? It was done with the help of Yeosela, 7% of interest for 20 years, and the real interest was 10% approximately, 2 million of the loan and 1 million approximately our savings. So regarding that loan, you still took that loan even though you had money to pay the house for the full price. We didn't have the full amount. You're looking at 2025, but in April, we didn't have that money. So 2024, you are talking about declaration for 2024, and based on the loan, given the loan that you took, you had enough money to pay the full cost. The CSO is asking, why did you decide to take a long-term loan, take a loan with long-term period of repayment without an obvious economic need? I'm not aware of the economic calculations that the CSO has made, but I don't understand what kind of methodology they used. The money we got, the income we got in 2024, 2025, we spend that income. There are daily expenses. So there was that program, Yosela, and the state is taking steps to facilitate the purchase of housing. And of course, any loan is not economically viable because it needs to be repaid with interest. But we took such a decision. Even more so, it was 20,000 per month, and that was viable for a family budget. All the income that we got, we could spend it on children and on everything we needed. Thank you. I've got no more questions at this time. Ruslan? Thank you. I'm Ruslan Sidorovich, member of the Commission, and I also wanted to clarify the following. 7% is lower than the inflation rate in Ukraine. So your money, in such a case, they did not inflate. And I'm sure you're aware of other mortgage programs. The difference between the real market value is paid by the taxpayers, by the public budget, and the bank that grants you that loan. And the objective of such loans is providing support to some vulnerable categories in this country, veterans, the youth that is still on their way to earn their income. So it's all about support to vulnerable categories with the taxpayers' generosity. So what you're saying, the state facilitated the purchase, and there was such a program, but public budget expenditures are much more multiple than the state can really provide. And you didn't seem to be in such a dire financial state. Was it a reasonable decision to benefit from this program? It's hard for me to understand your question, but I will do my best to answer it. Well, facilitating to purchase housing is public investment in economy, because if we have an active real estate market, then there will be offer in construction materials, in labor market. Well, there are, of course, some inflation risks, 7% only for the first 10 years, and then the full interest comes into play. And we considered it a public investment in economy, in citizens' good living conditions, and citizens are entitled to have 3% under Yosela. It's preferential loans. Yes, that's true, but this is investment. This is economy development. And in 2008, when the real estate market in some countries burst, we need to be mindful of that. And we did our best to contribute our money to buy this house, and we also paid taxes, more than 500,000 hryvnia. Well, my question was about your attitude to this loan, and that loan cannot be gotten by everyone. It can be received by anyone. You log in to your DIA and then you choose your bank, and that loan is limited by the amount of public budget. This is why it is limited, but it is fully accessible. Okay, thank you, colleagues. Any other questions? Let us come back to the issue of your self-recusal and your housing. So when in your answers you said, you informed us of your self-recusal, you said that you had a relationship with your wife, you had common duties and rights, and then when it comes to property rights, you no longer have any relationship with her. So for an outside observer, do you think that this very much this is very much like double standards? I don't think this is double standards. Under the laws and procedures, I could do that. We did not live together at that time, and you've got proofs of that. But for the CSO, you live together. For the self-accused, you live together, and after that, when it comes to property issues, we have a different situation. You're asking question in such a way, these are just facts. So it was impossible to handle the conflict of interest otherwise. It is a required by the law. My question is different. The circumstances that you state in your self-recusal application and the circumstances happening in the following 3 days testify to the conduct which is based on different principles. No, it is based on the same principles. Okay, thank you. Hi, Vitaliy Viktorovych. Alexei Melnik, thank you for this possibility to ask a question. I will ask you a question relating to your skills to administer justice as the judge of the appellate chamber, and to build on the question from my colleague regarding social products in the form of preferential loans. Could you tell me, please, are you using other social benefits, preferential programs that the state initiates annually that are quite known to the general public? 1,500 for living allowance and so on. So I am using the national cashback, and I'm transferring that money for the armed forces of Ukraine. Why are you not using other social benefits? Because they are also accessible. Well, most of them are widely accessible. You can just press the button and benefit from it. Why do you not use them? I don't know of all of them. If I knew, I would probably use them. My apologies, but I don't understand what you're driving at. This is why I cannot answer. Maybe I was trying to understand whether it is a principal position or not. So once you learn about such benefits, you will use them. I will take a decision after considering that. But do you agree with that? We're talking about Do you agree that the preferential loan is a social benefit? I believe that preferential loans develop this country's economy, but the basis of such a loan
ідея,
is
скажімо, підтримки найбільш вразливих верств населення.
this loan. The idea of support to vulnerable categories underlies this loan. This is a loan that supports those who would like to pay and buy their housing. Paying more than 1 million hryvnia is not something that a vulnerable category can afford. I'm having a hard time understanding your question. So the state supports any citizen having varied levels of income to purchase housing. And how does it relate to vulnerable categories? This is unclear to me. I understand why you're asking this question, but I don't understand with which purpose. Well, okay, let us not develop this topic any longer. So let us just agree that this is your position rather than a lack of understanding of the motives of the state. So let us come back to the criminal procedural code, in which cases the whistleblower is not entitled to reward, whistleblower in a corruption case. In case that whistleblower is obliged to report this information within his job description. So this is the only case, is it? In case it is their duty. Okay. And such a situation, it is well known, generally known, according to the criminal procedural code, the individual is entitled to a reward when they report about a corruption crime, and an unlawful benefit worth 5 and more subsistence minimums. But how about cases when individual reported, but the unlawful benefit was less than 5,000 5 subsistence minimums? Are they entitled to a reward? No, they're not. The law says that they reported, they fulfilled their duty. And they informed of a certain sum. I think this is up to the court to decide. After analyzing the evidence that had been studied, if the one sum was reported, but the crime targeted different sum, then we need to be crystal clear about which sum we're talking, and then make a decision. Okay, so we are taking into consideration, the court is taking into consideration the sum that was involved in a crime and that is proved. No. What sum was involved in the factual circumstances of the case? Because the accused could have received a lesser sum or a bigger sum. So if the unlawful benefit was less, so the whistleblower says it was 20,000 euro, but factually, in the factual circumstances, we are proving that it was 20,000 hryvnia. So the whistleblower made either so they made a mistake, but we need to understand with which intent. Was it with intent or not? Maybe it was a compromised whistleblower. Yeah, so it matters. It matters which sum it was. And there are cases when $100,000 is reported. And okay, so which reward is the whistleblower entitled to? I don't remember. Okay, thank you. I didn't have cases with these elements of the crime. Vitaly, could you tell me, please, whether an individual can be held liable if the limits of the pre-trial are not defined by the law? Does it influence the possibility of holding the individual liable? So, in a court hearing, the court that considers the case, the court determines whether the law was applied, had been applied correctly during the pre-trial, and because the time limitations were extended, the court can refer to a different article of the code, and also the rights and freedoms, whether they were violated in the process. And how that influenced the objectivity of that criminal proceeding. In October 2025, you made a decision on extension the time limitations to 9 months, and then a colleague of yours took a different decision in that criminal case. So, who does the judicial control over such situations? In October 2025, the judicial control was done by the Hague Court. The suspect and their defense turned to the Hague on multiple occasions in order to protect their interests. Some those motions were reviewed as appeals, and it was agreed that that case was subject to the jurisdiction of the Hague Court. Then there was no decision that the case should be transferred to a court of a different jurisdiction. In your opinion, should the Hague Court do the judicial control under Article 191 if damage is less than 13 million? The damage was not determined back then. I'm sorry. If the damage exceeds 6 million. I didn't have all the materials of the case at that time, and the parties did not dispute the matter of jurisdiction, and the case was considered by investigating judges. But the changes to criminal procedural code were made in July 2025. You are aware of them? Yes, I am. So was a notification of notice of suspicion of 6 million, but we could have had other information coming into play during the court hearing. Okay, one more question, Sergey. I will be brief question. I cannot but ask it because in front of me I have this candidate, and we are talking about a service official apartment, and that was highlighted in the social media, and I will not advertise that mass media, but this is a big media anyhow. It says that special attention is about the marriage of these two candidates, and for each 4-bedroom apartments were given as official apartments. So the mass media is infuriated about this fact. Is it true? So I have a deep respect to CSOs. Could you please explain? So there are some, of course, concerns about integrity of some judges, but we need to check them.
So you didn't get it, only Tatiana. Yes, only Tatiana has received it, and you didn't receive it. No, I didn't receive that housing. And if you look at this post, they even mention, sorry, let's go back to the issue of apartment. So let's not analyze the mass media post itself. It's not our topic of consideration. So, dear PCA members, do you have any other questions? Because we don't have any others left.
No, I don't think so, Mr. Chair. You have been quite extensive in your questioning. I don't think there's anything left.
Добре, дякую.
Okay, thank you. Mr. Vitaliy, over to you for your final words to clarify something, to add, to explain something to the Commission members and the PCA members. Now, I have no other clarifications or comments. I would like to say thank you to the PCA members and to the HQCJ members for giving me this opportunity to be present here, to participate in this interview, that you've asked me questions and you allowed me with an opportunity to reply to them. So thank you so much for that. Thank you. Yeah, I want to say that indeed you do so much of valuable and important work for the benefit of the judiciary in Ukraine. Thank you. Thank you for participating in this interview. The interview is announced to be over and the break is announced.